What is a NY VTL 1192-1 DWAI alcohol charge? New York's Vehicle and Traffic Law, Section 1192-1, creates a unique charge that many drivers don't fully understand until they face it themselves. DWAI alcohol stands for Driving While Ability Impaired by Alcohol, and it prohibits operating a motor vehicle while your ability to drive is impaired by alcohol to any extent. Unlike DWI charges, DWAI doesn't require prosecutors to prove you were intoxicated or that you had a specific blood alcohol content. The prosecution only needs to show that alcohol affected your driving ability to some degree, making this a surprisingly easy charge to prove. Police officers can support a DWAI charge through observations alone, including the odor of alcohol, bloodshot eyes, slurred speech, or poor performance on field sobriety tests. This means you can face DWI charges even if you refused a breathalyzer test or your BAC came back below the legal limit for DWI. The key difference between DWAI and DWI lies in their legal classification and the proof required for each charge. A first offense DWAI is classified as a traffic infraction rather than a crime, while DWI is a misdemeanor that creates a criminal record. However, repeat DWAI offenses can escalate, with a third qualifying offense within 10 years becoming a misdemeanor charge. New York law establishes specific presumptions based on blood alcohol content that can work for or against you in a DWAI case. A BAC of 0.05% or lower is prima facie evidence that you were not impaired, while a BAC between 0.05% and 0.07% can support DWI charges. The penalties for a first offense DWAI conviction include fines between $300 and $500, up to 15 days in jail, and a mandatory 90-day license suspension. Additional costs include court surcharges and a driver responsibility assessment of $250 per year for 3 years, totaling $750. While DWAI doesn't create a criminal record, the conviction appears on your driving record and can affect insurance rates and future sentencing. Former New York State Trooper Randall Inniss understands how police officers investigate DWAI cases and where those cases can be challenged. Taking prompt action after a DWAI charge can help protect your license and minimize long-term consequences on your driving record. Call the Inniss firm, PLLC, at 845-533-0265, located at 280 NY 211, Suite 203, Middletown, New York 10940, to discuss your DWAI defense options today.